Our Father, again, we give you thanks for the opportunity of gathering here. We pray that as we forge ahead now in our analysis of these matters that have to do with the history of our country, with the understanding of the meaning of the Constitution and its sources and roots, that our discussion would be in every respect filled with the presence of your Spirit and would lead us into a deeper understanding of these matters that would equip us in every respect to honor you and serve you better as your people in this country. We give you thanks for it now in the name of Christ. Amen. All right. Right at the conclusion of our discussion last week, we were talking about how the Constitution was understood. And the idea, you recall, was that the Constitution stands, in a sense, suspended between natural law on the one hand and positive law on the other. And we were saying that, in a sense, it participates in both, has one foot on each side of the fence. So it's reflective of and participates in the stuff of natural law. That is, it derives its nature from natural law. It is not natural law. The Constitution was never conceived of as an articulation of natural law. But the idea was that it, in a sense, is an immediate reflection of the values that we see in natural law. On the other hand, the Constitution has something of positive law about it. Positive law is law that is enacted by people. And the Constitution was enacted by people. So it has something of the nature of legislation about it. There was a consensus, you see, concerning the content of the Constitution among us people. And yet, in a sense, it's above positive law and would, in fact, serve as the instrument by which positive law would be evaluated. Now, the branch of the government that's charged with the task of using the Constitution to evaluate positive law is the federal judiciary, and particularly is the United States Supreme Court. The central responsibility, to put it kind of loosely, of the Supreme Court was to use the Constitution as an instrument to protect a level playing field in this country. Now, I say level playing field. That is to guard all of the delicate balances that were set up in our society. There was the balance, for example, that I mentioned connected with the Madisonian dilemma, the problem of the majority's right to rule on the one hand and the minority's right to not be invaded unduly on the other hand. A level playing field between majorities and minorities. The Supreme Court protects that level playing field using the Constitution. By the same token, the balance between the executive branch and the legislative branch is to be protected, you see, by the Constitution, so that each has certain powers, each is prevented from encroaching into the turf of the other. The authority between the federal government and state governments was, again, a balance that the Constitution was seeking to protect. And the idea was that no authority could be wielded by the federal government except that which was given to the federal government. That particular task, if you'll pardon the editorial comment, has been largely abrogated by the Supreme Court in recent years, so that virtually every time any question comes up involving a power struggle between federal government and state government, the problem is resolved in favor of the federal government. And that has been the case for several decades, but at least traditionally the idea was to achieve a balance between those two governmental entities. Now the question is, if the Supreme Court is charged with the task of using the Constitution to protect, as I say, the level playing field, what binds the Supreme Court? You can see that it has, in a sense, an umpire's role. It's out there with the striped shirt, making sure that all the players play fair. And the rule book in the back pocket of this umpire is obviously the Constitution. And the question naturally arises, well, what binds the Supreme Court? And the obvious answer is the Supreme Court is bound by the rule book. So that the task of the Supreme Court is not one of rewriting the rules or revising them or remodeling them, but enforcing them. See, that's the intended function. The Supreme Court is there guarding the play, calling foul, if someone overreaches their particular task. But the Supreme Court is not charged, at least originally, with the task of making up new rules. Of saying, this situation requires some new principle of constitutional theory and actually, in a sense, interlineating and adding new propositions that were never part of the original content. That's not part of the Supreme Court's task. The question I want you to think about is the one I was raising at the end of our discussion last week, and I want to pick up right where we left off then with this lengthy review that I've given you now. How does the Supreme Court decide what the rule book says? That's the question I want you to ask yourself. How does this umpire in our society decide what the rule book says and what it means? Now, I'm going to submit to you tonight that there's only two possible answers to that question. And I'm going to distinguish them by these two words: objective and subjective. Now, I realize that's a little simplistic, and certainly it could be argued that we could have hybrid responses that would be a combination of both, but for purposes of clarity, I'm going to reduce it to those two. That really, the way in which the Supreme Court decides what the Constitution says is going to have to be one of these two. It's either an objective approach or a subjective approach. Now, when I say an objective approach, I mean what is classically referred to as, quote, original understanding. That's the term. And the idea here is that the Supreme Court's task, if it's going to objectively approach this issue of what does the Constitution say and what does it mean, is charged with the task of deciding what was the original understanding. In other words, what did the people that wrote this document intend it to mean? Now, that might seem to you like a pretty obvious approach, you see. In other words, when the baseball umpire is out there calling the plays, his task as he applies the rules is to ask himself the question, what was this document, these rules, what were they intended to mean? He's not charged with the task of inventing what he thinks they ought to mean, but simply applying what he believes they do mean, objectively, apart from his personal bias, you see. And traditionally, that's been the role of the Supreme Court. That was its task, was to ask the question, what was the document intended to mean? Thus, this is what could be called a deductive process. The court is charged with asking, first of all, what's the major premise? That would be, what does the Constitution say objectively? Secondly, what's the minor premise? Namely, what does the particular fact situation before me suggest? Applying the major premise of the Constitution to the minor premise of the fact situation, drawing a conclusion as to how this legal question should be resolved. Now, I just want you to understand that is not an outlandish concept, you see. That's the everyday business of judges across this country. Here in Spokane and across the nation, judges sit behind benches every day asking the first question, what does the law objectively say? Secondly, what does this fact situation supply to me as information? And thirdly, if I apply this law to these facts in a neutral way, what conclusion am I necessarily driven to? That's the business of judges. And originally that was understood to be the business of the Supreme Court, to do the same thing, only doing it with the Constitution and applying it, you see, to the facts that would come before it. This is the task of the Supreme Court, and it is to be carried out apart from the personal biases of the judge. In other words, a judge might be confronted with a situation where the judge doesn't like the results when he applies or she applies the major premise to the minor premise and comes to a conclusion. But the fact that the judge doesn't like the result in no way changes the fact that that is the result. And that's the task of the judge. And again, it's just part of the professional discipline, hopefully, that a person develops as they're engaged in this business of practicing law, either as a lawyer or as a judge. asking the question, what does the document intend to say? Now, most important, this objective approach to the Constitution also implies this. If the document is silent as to the particular fact situation, in other words, a fact situation comes, it may be an egregious, offensive situation. My moral instincts might be driving me to wish that I could resolve this thing in a certain direction. But if the Constitution is silent, then the Supreme Court is charged with the task of saying nothing and letting that problem be resolved at the legislative level. Because the task of the Supreme Court is not to begin implementing its own moral instincts, but just to apply the Constitution to the facts. A very limited function. All right, that's the objective approach. The subjective approach is just the opposite. The subjective approach could also be called the contemporary approach, as opposed to the original. The subjective approach is also inductive as opposed to deductive. What it means is this, that the fact situation is presented and the judge has a certain instinct as to the desired result. This is the way this fact situation should be resolved. So taking the desired result and reasoning backward through the facts to the Constitution and building some kind of bridge between the desired result and the facts and the Constitution, but moving in the opposite direction, you see. Now, to put it in those terms sounds very cynical, but in fact, that has tended to become the operating program that's taken place pretty much wholesale, you see, in constitutional lawmaking and decision-making. But it's just in the reverse order. So it's beginning with the desired result, the subjective result that is desired, and reasoning back, building bridges to the Constitution. The natural effect of that is that it results in the Constitution speaking at a lot of points where the framers had no idea that they were speaking, you see. Filling in a lot that the framers had never dreamt of in terms of constitutional content. Now, what I want you to think about for a moment is this. Classically, the task of the court was to ask the objective question, what does the Constitution say? The contemporary approach has become decisively one of asking what is the desired result and reasoning back into the Constitution, looking for some justification for that result. The Constitution was originally understood as reflecting absolute values, values that are metaphysical in character, that are normative in character, that are connected with natural law which can be known. The judges were not charged with the task of applying natural law. They were charged with the task of applying the Constitution on the presupposition that the Constitution reflects natural law and that natural law doesn't change, that it's fixed, as it were, in the nature of things. That's why traditionally in this country the study of Blackstone was axiomatic to a legal education, because Blackstone's theory was that there is natural law and we apply natural law in jurisprudence, and that's really the task, you see, of legal thought and legal scholarship, is to see the implications of natural law applied at the level of practical law or positive law. That's the classical approach. The contemporary approach has tended to disdain original understanding. Now, that may come as a surprise to you. It doesn't come as a surprise to any lawyer to realize that there is virtually no interest at all in what the document was intended to say. That is almost regarded as an irrelevant point, you see. I think anyone that goes to law school, the one thing they aren't exposed to in a class on constitutional law is what the Constitution was intended to say. You see, that seems to be disregarded as wholly irrelevant to the question. Now, you might think that's very strange. That seems very odd, and I think at the popular level in this country, that's not really understood. And it's part of the reason that, you begin thinking of lawyers as being kind of cynical. I'll never forget one of the most influential professors that I had in law school was one that I took 2 or 3 classes from, but one was called Constitutional Law. And he must have said, in the course of that study, maybe on half a dozen or more different occasions, at the end of the discussion, at the end of the lecture, the climactic declaration he made to this class of fledgling lawyers was, "So you see, ladies and gentlemen, the Constitution is just another scrap of paper." And he was right. That when we look at what is done with the Constitution today and compare it with its intended meaning, we realize that it's purely arbitrary in many ways, how the Constitution is being applied. Now, let me just illustrate this in the most simple kinds of ways, but just using these 4 values that I've already mentioned. The notion, for example, of the religious aspect of life. You don't have to read very far in Jefferson. You don't have to read very far in Franklin or some of the other thinkers who are so formative at the time of the founding of this country to realize that they were wholly committed to the idea that religious training should be part and parcel of any educational process. And that if a person is not trained in things religious, along with, reading, writing, and arithmetic, that if that is not part of the content, then that training is seriously deficient. That's not something that's subtle, deeply buried in levels of esoteric, obtuse, scholarly statements that is hard to find. It's right there on the surface of it. It's an absolutely obvious aspect of the thought of the framers. Now we have the Supreme Court telling us that a Constitution drafted by people who had that kind of mentality, that Constitution prohibits prayer in school. Now all I want to say, I'm not militating either side of that question, just simply saying to you that would have been the most bizarre idea to the framers that you could possibly think of. To think that prayer would be prohibited in school would be utterly unthinkable, and to think that the Constitution could be used to prohibit prayer in school would be staggering, to say the least. 180 degrees out of sync with its intended meaning. Or you take an idea such as sexuality. The framers were quite clear as in terms of what the appropriate context is for the sexual expression. It's something that is a good thing, a pleasurable thing, a happy thing. It has its proper context. We now have a value system that says that sexual expression, regardless of where it takes place, is an absolute constitutional right, and that the state has absolutely no right to intrude on that private interest. That would be an unthinkable thought to the framers. And to think that the Constitution is used to buttress that proposition would bowl them over. They would wonder, how could that be? The framers were committed to the idea of hard work and industry. The present constitutional theory has to do with entitlements. What are your rights? What are your entitlements, you see, in terms of government benefits? It's a wholly different philosophical idea from what would have been in the minds of the framers. What does government owe me, you see, is kind of the prevailing idea. The notion of life. Traditionally, there was a heavy commitment to the idea that life has an independent and intrinsic value. It has a sanctity. The prevailing idea today is called quality of life rather than sanctity of life. Now, I just want to say to you, at this point, I'm not again militating to either side of this question, just simply reporting to you that philosophically, the notion of quality of life is connected with a humanistic understanding of what life is that relativizes its value. It is simply saying that the value of life is related to its quality, and that there is some point, and if the quality of life goes below that point, then the value of protecting that life is lost. That life doesn't have a value apart from its quality. Now, I'm not sure how you decide what quality is. I don't know who's giving us that standard, but the idea is that if life does not have quality, then it does not have value. The original notion was that life has an independent value just because it's life. The task of the state is not to speculate about the quality of the life, but to simply respect the sanctity of the life and protect it because of what it is. Now, again, I'm not trying to pick a fight with anyone. I'm just saying we don't have to go very far in terms of reading the framers to see those values. This is not something that's hard to discern. It's very obvious in their writings. I mean, just pick it up. Read the autobiography of Ben Franklin to convince yourself of this. Read some of this. It's great stuff, and it'll persuade you that the intended sense of the Constitution, the intended thinking of the framers, is wholly different than the applied sense of the Constitution today. That's my only thesis. I really don't think that can be significantly disputed. In fact, I think anyone that actually did try to argue that the Court is today applying the sense of the Constitution as originally intended would be laughed, out of the room, because it's so obviously not the case. The question I want you to ask yourself, though, and more to the point of our discussion tonight, is how did it happen? How did that happen? I mean, was this just a gradual evolutionary process? That we just got wholly out of step with the framers? What happened? Did we just wake up one day and say, my goodness, those were very naive people, and now we should, basically take a 180-degree turn and everything that they held as an affirmative proposition we should deny, and everything they denied we should affirm, because now we've come of age or matured as a race or whatever. Is that how it happened, or was it? What happened? You see, that reversal could occur. It really is a remarkable thing. And it's happened in a fairly short period of time. Because even if you go back to the turn of the century, if you go back to the 1900s, you'll find that even at that point there's still quite a conscious effort to apply the original sense of the Constitution, very clearly there. Not always carried out successfully, but certainly part of the intended discipline. Now, it's ignored. What happened? When did it happen? In many ways, it happened during your own lifetime. Some of you have been at least intuitively aware that this has happened in fairly recent American history. And what I'd like to deal with tonight briefly is how did it happen? Now, to do this, I have to become, again, my apologies if you're getting tired of this, a little bit philosophical. But these things always begin at a philosophical level and trickle down. So, if you'll pardon me, that's what we're going to do. I believe the answer to the question, how did it happen, has to be understood in terms of two great figures. One of them is a man by the name of Immanuel Kant, K-A-N-T, and the other is a man by the name of Oliver Wendell Holmes. But we need to look at both of them. There's a clear connection between them. But in order to understand Holmes, we have to begin with Kant. Immanuel Kant was born in 1724. He died in 1804. Therefore, he lived through, of course, the American Revolution. His philosophy, however, didn't hit the bloodstream of other thinkers until some years after his death, which always is the case. These notions begin in philosophical worlds, and they trickle down, and it usually is several decades before you see it hitting the bloodstream at the popular level, of what was being developed at the philosophical level. So again, interestingly, Kant is doing his work at a time when the framers are very impressed with Locke, who's 75 years earlier. But that's kind of the way it goes. You see that sort of after-the-fact impact. Kant is attempting to accomplish a couple of things. He's impressed with the age of reason. He's still connected with it. He sees the great tension. If you've been in this class now the last few weeks, you'll recognize these terms. He sees the tension between Descartes on the one hand and Hume on the other, between rationalism and empiricism. He sees the problems, the unresolved tension. He sees how reason, how rationality seems to be crowding religion and faith into a corner, undermining it. And he's concerned about rescuing both religion on the one hand, faith, and also reason or scientific enterprise on the other, because he sees them on a collision course. And he wants both to be protected. Kant is triggered into his work by reading Hume. Now, I mentioned Hume a couple of weeks ago, and I said we'd come back to him, so now here we are, as promised. Hume, you recall, was the extremity in the age of reason. We began with Descartes. Remember the pendulum swing and we wound up with Hume. And I said he was the radical empiricist. Locke was a compromise. Hume goes the distance. Hume has an axe to grind. Hume undertook the task of destroying, if possible, the classic arguments for the existence of God. He was an antagonist of the Christian faith. One of the most formidable opponents that the Christian faith has ever dealt with is David Hume, a brilliant English philosopher. The way that Hume undertakes this task is by demonstrating that the classic theistic proofs, those arguments for the existence of God that come down from classic philosophy, this would be like the cosmological argument, the teleological argument, the ontological argument, these arguments for God's existence out of reason. Hume argues that they don't work, and that those arguments do not prove that God exists. To cut right to the core of his reasoning, it goes something like this. All of those arguments depend on a presupposition of causation and a presupposition of non-contradiction. Now, you should remember those from Locke. Remember, Locke talked about we're principally educated by empirical experience, but we have these internal ordering principles of non-contradiction and causation, and that's how we make sense out of our empirical experience. That was Locke. Hume comes along and says that's nice, but please bear in mind nobody has ever proven that there is such a thing as causation. And nobody has ever proven that there is such a thing as non-contradiction. Those are presuppositions, and they cannot be proved precisely because they are presuppositions. You don't prove a presupposition, you presuppose it, you see. And so Hume is saying the classic arguments for the existence of God are only as valid as the laws of causation and the laws of non-contradiction, which cannot be proved. And because we cannot prove those, we cannot prove God. We don't know if there is such a thing as causation. We just think there is because it seems to be that way. I might mention to you, by the way, this is a side, Hume hasn't died, and if you've listened to, I hope I don't get anyone upset with me, but, it's getting toward the end, and I'm going to start becoming more reckless. But, this tobacco industry has been militating for years, has never backed down from its position that smoking has never been shown to cause cancer. And that is Hume. That is Hume applied in the 20th century. And they can say that in the face of all the statistical evidence, because all of that evidence is at best circumstantial. Nobody has ever shown what the causal connection is. And I'm going to tell you something. There's a good chance nobody ever will. Because causation is not something you can see. It is something that seems to be. But how do we know? Maybe it's coincidence. And that's what Hume is saying. Maybe all of the things that seem to be causation are just customary relationships. And there's some other explanation. On that premise, he overthrows and defeats the classic arguments for the existence of God. I'm going to take a break here, but I want you to bear in mind one thing. Hume tacitly acknowledges that if there is such a thing as causation, and if there is such a thing as the principle of non-contradiction, the classic arguments for the existence of God work. Which many contemporary Christians don't realize and have tended to capitulate at a point where they didn't need to. All right, let's take a break, and we'll come back in 10 minutes.